Good morning. Good morning to Ryan Abbott, patching in from California, and good afternoon from James Tumbridge and myself, Christian Gordon-Pullar, here in England.
Hello.
It's a pleasure to have Ryan and James together today. It's a rare occasion. Once every 2 or 3 months, we manage to get together. So for those of you that may have missed Ryan Abbott's stellar series of DABUS cases, Thala, and his excellent book, I have the pleasure of introducing Ryan Abbott, an American academic, lawyer, physician, patent attorney, all-round scholar and excellent human being, who works at the intersection of AI, intellectual property, and health law. He holds an MD from San Diego, a JD from Yale, and a PhD in law. Sorry, I can't tell you how jealous I am. And is licensed in multiple jurisdictions, California, New York, England, and Wales. And Ryan is probably best known for being not just a professor of law and sciences at the University of Surrey, but also having worked in private practice in the US and now a consultant to Keystone Law. His book, The Reasonable Robot, is how I met him at the House of Lords in England. But I think most of you will be aware of his involvement in the variety of DABUS cases, the DABUS and Thala cases, where he pushed for the idea that AI can be named as an inventor, litigating in multiple jurisdictions, including the UK Supreme Court and the Court of Appeal. So, Ryan Abbott.
Well, thank you, Christian. You're making me blush. And it's my turn now to introduce my partner, James Tumbridge from Keystone Law. James is a prominent London-based intellectual property litigation lawyer, mediator, and arbitrator. He's a partner at Keystone Law now. He was previously a partner at Venner Shipley, and prior to that in senior roles as a partner or counsel at Pillsbury, Winthrop, Shaw, Pittman, and Gowling, with additional names I can't pronounce. His legal specialisms include intellectual property litigation, data protection, alternative dispute resolution, advising on election law and regulatory compliance. He's acted internationally in the UK, US, Canada, and European jurisdictions, has appeared in high courts in multiple countries. And beyond his legal practice, James is active politically and in local government. He's a common councilman for the City of London Corporation since 2009 and has served as a councillor on the Brentwood Borough Council. He's also chaired committees such as the City's Licensing Committee and more recently the Digital Services Committee. Earlier in life, he grew up near Diss on the Norfolk-Suffolk border, funded part of his education through service in the Territorial Army, Infantry and Signals, qualified as a barrister, and spent time living and working in Canada and the US before returning to the UK. He has written and contributed to legal books on subjects including intellectual property, employee inventions, trademarks, and the common law world.
Wow, I'd forgotten half of that. So thank you very much, Ryan. It's very, very kind of you to give me that introduction. Then my turn to try and do something for Christian, who, of course, is a distinguished lawyer and has a long experience dealing with technology issues, intellectual property, cyber, financial services. He started with what is now known as Hogan Lovells, formerly Lovell White Durrant. He then moved into the in-house world and was the group legal counsel at Standard Chartered Bank in London, spent time in Singapore, Hong Kong, was later with JP Morgan, and has a great deal of experience from the Asia Pacific region. He was an executive director and head of legal for technology, IP, and corporate functions for JP Morgan. He oversaw the legal coverage in relation to all technology, cyber, fintech, outsourcing. Quite frankly, it sounds like anything that wasn't physical, Christian was there. Active in shaping policy with the Global Advisory Council for the Future of Intellectual Property at SagaciousElevate. He's contributed to the All-Parliamentary Group on Artificial Intelligence in the UK. And he's been recognized for the last 5 years by IAM as a leading global strategist for intellectual property, listed amongst the top 300 strategists in the world. He has a background education in pharmacology, law, has an MBA from Temple University, the Fox School of Business. He's also known for combining his technical understanding with the strategic leadership on emerging technologies. So hopefully, between the three of us, we might know something of interest.
And something of interest about the evolution of artificial intelligence, the adoption of it, and more interestingly, I suppose, to start, where we have a core intersection of our three specialisms, the law, and how AI is evolving with the law and how the law is evolving with artificial intelligence. So I suppose, Ryan, if I can kick off, in light of UK's rulings like DABUS and others, should we be starting to contemplate granting AI inventorship or authorship rights as they do in the US? Or is the fact that the US has a different set of standing existing legislation where inventorship and naming the inventor is more important than it may be in other jurisdictions, is that perhaps the reason for different approaches across the pond?
Sure. Well, all questions near and dear to my heart. And I guess to back up a bit, we might ask a broader question, which is, now that we have AI stepping into the shoes of human inventors, now that you could ask ChatGPT to invent something for you or improve an invention or draft a patent or draft patent claims, how do we want to deal with that sort of behavior? And what does the law say about it? And what the law says about it is often not that clear and is very different in different jurisdictions because the law wasn't written kind of with the thought that you were going to have AI doing inventive activity. The US approach was similar to the UK approach. Both decided you could not name an inventor. But in any case, kind of naming an AI as an inventor was never a matter of providing a right to an AI. And though there can be rights associated with inventorship or authorship, that is not necessarily the case. Most inventors don't own their inventions or have any right to their inventions. Most inventions are owned by companies, which are artificial persons, and they typically own these because they employ human beings who do inventing for them. And in some jurisdictions, you don't even have to name a human being who contributed something. On the copyright side of thing, when you're talking about authorship, that's where you have some very different laws. In the UK, they changed copyright law in 1988 to say if you have an AI author something, the work still gets copyright protection. It's called the computer-generated work. It gets a shortened period of protection, and you legally deem or fictionalize the human producer of the work to be the author.
Yes.
The US doesn't have a law like that, but it does allow non-human authorship and has for a century. It's an international outlier in that respect, but you can have companies be authors. And when you do, there's no requirement to disclose any kind of contribution by a natural person. So all of this is kind of very interesting and being pressure tested by the use of AI. And 5 years ago, these were academic questions that I thought were hugely interesting for theoretical reasons. And now, particularly in the authorship front with, generative AI becoming phenomenally better just month by month, particularly the copyright issues have become important. And they're important for a lot of reasons, to me, mainly because of subsistence. So a work needs an author, an invention needs an inventor to get a patent, generally, or at least that's been the assumption. So what do you do if that author or inventor is, factually not a human being? Do we treat this like a company made it? Do we pretend that a person made it? Do we look at a different sort of contribution, like training an AI or using an AI, even if you haven't done something that would be traditionally inventive or authorial? So for me, the way I come at it, I think, we should look at the purpose of the law and be a little less textual on it. And for me, these patent and copyright laws exist because we want to encourage certain sort of behaviors that result in more beneficial outputs, whether that's creative or inventive outputs. And I think we want the law to function however we best get those outputs, whether we're using people or machines.
That's interesting, and I wanted to pass that on sort of also to James with a slightly different view, James, right? We look at copyright in the UK because we have the computer-generated works provisions of the Copyright Designs and Patents Act as amended, but also we tend to have, and I say this with a little bit of a smile, looking across our little channel to our French and European friends, a more author-based, a more creative content recognition. And perhaps that, as Ryan pointed out, is more of a a sense of direction that governments and also legislatures are looking at. Are they protecting industries that are content creators? Or are they protecting and trying to encourage industries that are technology creators and technology owners? And perhaps that's an angle that we see slightly differently, perhaps in the UK.
You could well be right. I mean, I didn't expect to have to expose early on that the two of you are clearly greater thinkers and more academic than I am, because actually I was listening to Ryan's comments and listening to the way you've posed that, and I start my thinking on it with a historical and human context and then a practical future focus. Because about 5 years ago, when Ryan was beginning to educate us all, this really matters. At the time, I may well have said, does it really matter? You know, if it's a human using a tool, we've had them using stethoscopes and microscopes and goodness knows what forever and a day. It's about human ingenuity and a person recognizing something is an invention or something is creative, and that if it's just a tool, does it matter? We've gone a long way. And of course, let's touch on the history. The history, you know, this glorious thing called patenting, it was a gift to the world from England for questionable means in some ways, because it was a way for the crown to make a lot of money by giving people monopolies. But it did develop, it did evolve. And therefore, it came from the creative starting place of, we'll give you a monopoly for a certain period, provided you tell the world how to do this, so that when your monopoly expires, it moves on. But it has that historical creative element. Copyright's a bit the same. And then I come to, well, where is my mind at today? My concern today is that what people refer to as AI, which can be quite a broad thing, let's not get into the definition on what is and is not AI just this moment, but AI is so much more than a tool in some cases. And in Ryan's example, in the cases he's been bringing, he's been explaining how it can be set up to independently find a problem, find a solution. Now, let's take that into the world of pharmaceuticals. It's often overlooked that we've been very lucky in the world, and the Western world in particular, that without excessive public expenditure, private enterprise has taken the risk and tried to solve medical problems. And why do they do that? Well, even though it costs a lot of money and a lot of time, they get their monopoly and they hope to earn back their income. Now, if you can't protect the next blockbuster cancer drug because it was too AI focused in its creation, will they continue to invest in our medical future? That's the practical issue in my mind. That's why it matters. Because if we're talking about the societal benefit, it's now perhaps going beyond human creativity. Because if people stop investing in things like that because the law has become outdated, I don't think that's a good thing.
That's really interesting, James, because, and you know, I think both Ryan and James know that I sort of sit somewhere across these two views. Just to give you my sense of this, I think also just to go back, as you say, to basics. I think, yes, there is a difference in the particular specific current needs of legislative change and alignment in the US versus the UK and elsewhere. But if we take the basic principle that we, the world, and lawyers in particular, the profits and proselytizing the corporate veil, we created the concept of the legal entity as a separate legal person, which doesn't actually have people. And there comes with it a certain ring fence around that, both for liabilities, involvement, directors, and so on. But today we know, both for the benefit of the creators, that an inventor sometimes does have some interest in the inventorship and the patents, because for their own personal gain, they get publication rights, or they get inventorship rights, or they may even get a tiny percentage of the royalties that the company makes. But even if they don't, their name is on it. Today, if we use a tool, and that includes companies that are using AI to find new models for pharmaceuticals or molecular products, or combinations of molecules that work with particular drug preparations, it's still true that we could simply solve that by allowing a company to be exactly what it is today, which is to allow its people and its technology, which is beholden to it and paid for by it, to then be represented in the patent or copyright world as the legal entity that actually directs or owns that. If to the extent that AI does become entirely autonomous in how it does this, then the question I have is, if we don't give the AI a legal personality, perhaps some taxes that go with that, you're going to be losing something, both for the individual creators, the companies that paid for it to be developed, and ultimately for the governments who are trying to get some income tax out of the whole process. I'm sure there'll be some elements of that in our next podcast. So just some thoughts on that, and maybe some closing words from Ryan and James.
I think that's a very good idea, because, you know, let's save something for the next one on the tax front. But I think where I come from, I'm still sort of very much grounded in what I was taught by professors at university, that there's a bargain here. Protecting creativity, protecting creative people is a good thing for a limited period. And that's why we have certain periods. And I think all I'm sort of picking up is that I still want a system that recognizes and protects creative people. But if the creative element becomes too digitized, will people stop creating or create ineffectively because they can't enjoy any outcome? So whether you're protecting creativity for the human or creativity for the community good, I think the law has to keep up with that.
I think that's true. James, Ryan?
Well, no, I think these are great questions, and they raise all sorts of practical questions and all sorts of deep philosophical questions about, you know, what corporations are and how we treat them and how we should treat them, and whether we impute human mental states into corporations. You know, from my perspective, you know, there's a lot of reasons that people or companies invent. You know, I come from a life sciences background where, you know, in medicine development, the patents are very important because you have to raise enormous sums of money to do clinical tests. And so the issue there is, can the company get a patent? And they don't really care so much who the inventor is. But also, you know, this varies by jurisdiction. In the United States, it's not a matter of complete autonomy. It's a matter of, you know, doing something involving inventive skill effectively. Yeah. So, you know, is an AI a tool? Well, it's being used to do useful sorts of things, but it can automate things that used to make a human being an inventor. You know, increasingly, there's a bunch of multi-billion-dollar valued companies now that say their AI is inventing drugs, and you can give it very broad directions, and it will go find technical solutions for you. In a circumstance where if you had given a human being that direction and they had come back with a solution, they would be the inventor. The person giving the direction would not be an inventor. Now, in the United States right now, the patent office says that means that work is inherently unpatentable if AI does too much. In Germany and Switzerland, they just said, you know what? You need to have a natural human inventor. It doesn't really matter what they do. We're not the United States. Just list someone on it. You could list the owner. You could list the user. You could list the person who develops the thing. You could list the first person to see it. And in the United States, you might say, well, if I say invent a better drug to treat, you know, cancer, and the AI says, I've generated 1 billion virtual molecules, tested them all against these known cancer receptors, and here's what I think the #1 candidate is. Here's how to formulate it. Here's how to design clinical trials. And the person who gets that hands it to a patent attorney, and that's all they do, and they don't know how the AI works. They don't understand the underlying science. You know, in Germany, that's fine, and in the US, it isn't. And, you know, maybe now that AI is doing this sort of thing, we care less about what it takes to be an inventor, and maybe the whole concept of inventorship fades away a bit, and it's more about property right ownership. But these are fun questions to be asking.
Yeah, that'll be an interesting one to then carry on in our next podcast. Just leaving you with a few thoughts. I think we clearly have a variety of different views, and I think perhaps that is one to be explored in the next next issue of this podcast. But to leave you with a thought, I think many governments have thought about finding a compromise between the lengthy copyright periods and the equally lengthy, but 20 years for patents, and recognizing that AI has a life cycle that is much faster, where the evolutions and the emanations are much quicker. Perhaps the idea of granting AI rights or patentable copyright to AI systems that has a shorter period might also recognize the fact that they are faster and develop more quickly. And perhaps the obsolescence will be also an interesting factor as we go into the next generation of this. And so thank you to James and Brian for a very interesting first podcast. We'll see you again soon.
Thank you.
Cheers.
Thank you.